This is the Mortgage Crisis Update on 630 WMAL. Listen as Compliance Counsel's Dena Roudybush leads you through a fast-paced half hour of expert advice designed to empower you and help you fight foreclosure. Now your hosts, Dena Roudybush and Rick Fowler.
630 WMAL, I'm Rick Fowler, and it's time for another Mortgage Crisis Update. We are joined by Dena Roudybush. She is an attorney who is an expert in representing homeowners when it comes to everything from foreclosures to refis to loan modifications. Dena, it's great to have you back with us.
Oh, wonderful to be back. Thank you.
Over the past several months, we've been talking about a very important piece of legislation in the Virginia House as it relates to homeowners' rights in Virginia. Bring us up to date on House Bill 1506. Real quick, what is it and what's the significance to the homeowner, and then what's next?
House Bill 1506 would extend the notice of foreclosure from 14 days in Virginia to 45 days. It's my position, as well as Delegate Marshall's, that 14 days is just insufficient time to give notice to Virginia homeowners of their foreclosure sale date. And it would also require assignments to be filed in land records. And as listeners know from previous shows and updates that we've given, one of the biggest problems in the industry right now is that lenders are not recording assignments, so homeowners are left with no information as to who the secured party is on their note. So this House Bill 1506 would require that the lender file an assignment in land records just to prove who the secured party is for that property for the homeowner.
When we've gotten into detail on it, it's kind of a no-brainer for the homeowner. Mm-hmm. What's somebody do to get behind that?
Contact Governor Bob McDonnell at 804-786-2211. That's really the best way to show support, to contact our Virginia governor at 804-786-2211.
I've been hearing about a new trend among mortgage lenders when it comes to foreclosures and short sales. And what can happen is a consumer gets a big surprise 30, 60 days later, and it's not a good surprise. Tell us what it is and how to avoid it.
What a lot of people may not know, if your lender approves your short sale, or if you've walked away from your property in a foreclosure, you have a deficiency balance that's owed. Unless your lender has specifically agreed to waive any deficiency in your short sale, you're going to have a balance that's owed. There's a debt that's owed. That's the difference between what they've agreed to sell that property for and the balance that's owed on your note. The same thing with the foreclosure. You have a balance that's due to your lender and what they've sold that property for. The trend that's occurring right now in the industry is that lenders, they're either holding on to that deficiency judgment, but more that we've seen since January of this year, they're starting to pursue that deficiency. They're filing deficiency judgments, and the reason being, at least in Virginia, you can file a deficiency judgment, and you can renew that judgment for up to 30 years. So if they get a judgment now, they're going to wait. That's my prediction, that they're going to wait until the homeowner or the borrower, they're back on their feet, they've got their finances back in control, and then they're going to go back and try to garnish wages or levy assets or whatever means they can to collect on that deficiency. So it's so critical for anyone, either in the short sale process or even going through foreclosure, to be mindful that there's a deficiency that lender is going to collect on or try to collect on. It's not every homeowner, but if it's a primary residence, investment property, that is something that they're pursuing right now.
Now, if you're doing this on your own, and let's say you don't have an attorney, is it something that's made abundantly clear to you when you're going through that process, or is it something that nobody really brings up until a month or two later?
No, and that's the problem right there. A homeowner without an attorney, just working through a real estate agent, they get an approval. And most people, and even I would assume, approval means it's approved, it's done, everything is agreed upon. But what's silent is the fact that they have not agreed to waive that deficiency balance. So that's the one key component to the short sale process. Specifically, if you're going through the short sale process, you need to negotiate during the process, not after, to waive that deficiency balance.
If someone's listening that's facing a foreclosure, they probably don't think they can even add more expense and afford an attorney. So what do you say to somebody in that position, Dena?
That's a good question, and because our firm is consumer-oriented, we've built our rates to fit the consumer. Our rates are very competitive so that homeowners who are in these situations facing financial distress, unable to make their mortgage payments, are able to afford our services to either fight the lender in foreclosure defense litigation, file bankruptcy, or negotiate their settlement. But we represent hundreds of homeowners, and, for example, we had a client that came to us after the foreclosure sale when they were facing an eviction, and now what we're able to negotiate is a settlement where they're either going to get a loan modification and stay in their home or walk away with a significant in the hundreds of thousands settlement because the lender had so terribly fouled up the foreclosure in their case.
So I guess what I'm hearing here is if somebody doesn't have legal representation to at least take a look at all this, a foreclosure could be based on erroneous information or some mistake, and you're just going along with it because you think the bank and the mortgage lenders know what they're doing at all times. There have been mistakes made.
Oh, absolutely. Especially in Virginia, we're a non-judicial foreclosure state. Maryland is quasi-judicial. So in Virginia, you would not even get to the courthouse or a judge's review at all. The lender would steamroll right over the homeowner if it was not for an attorney reviewing the documents to ensure that everything was done properly. In Maryland, you do need a judge's approval, but there are several requirements in Maryland, but that does not necessarily dictate that the lender or the trustee will follow those requirements absent an attorney ensuring that that's done for the protection of the homeowner.
Dena Roudybush at Compliance Counsel. Somebody wants to get a hold of you. Best way to do it?
703-261-7097.
And you don't mind taking a call, at least to walk somebody through it on the phone and see what's going on?
Oh, absolutely not. That's what we do.
Dena Roudybush, 703-261-7097 at Compliance Counsel. Website is SaveYourHouseLawyer.com. That's SaveYourHouseLawyer.com. Dena, always great to have you with us. Thanks.
Thank you.